set up his business in 2000.
We haven't got, or if we have, I've overlooked it. We haven't got the EL test document. It clearly was shown to the judge. The judge noticed that it was what he called 5.5.
Not a flamboyant score, no.
And she said that means it is she, isn't it, Judge?
It's he. It's a he.
Sorry?
It's a he.
It's a he.
Judge O'Callaghan is a he.
That's my fault. I thought I'd seen some reference to Denise.
No, his first name is Declan, if I may put that.
Declan.
Declan. Yes.
My fault. I led my lords astray.
Anyway, he
yes, the score, my lord.
He says partial competence. Yes. 5.5 is
it gets you into the United Kingdom.
Yeah.
To show you that you've got a relatively good command or a steady command of English. But what then happens is the appellant applies as a Tier 1 entrepreneur, and that is a very rigorous application. My learned friend will agree that the Secretary of State does not grant visas or extensions of leave very readily.
Remind me when he made that application.
2012, my lord. And that was granted.
Is that is the application for which the TOEIC certificate was put in? Yes, I see.
And he was then, in the note of hearing, your lordships will have noted there was a discussion of an interview that took place in 2016. In the latter part of the note of hearing, the presenting officer does agree that there was an interview with this appellant in 2016 where he was asked about the TOEIC. And within that interview, the appellant gave the same evidence that he has given right the way through in relation to how he travelled to the test centre, why he chose the college in particular.
That's right, but you're back on the point you've made already about consistency.
It's about consistency.
Now, I just want to make sure I've understood your point. You very sensibly said this isn't the main point, but we've got to deal with it. The point is about his level of attainment of English in July 2012. The point being, which he was making, which is very commonly made in these cases, is I had no need to cheat because my English was very good already. So the question was, how good was your English already? And what is the evidence that it was very good? The schooling is, as you say, there are no certificates. That's rather too vague to place much weight on.
Yes.
The one document we've got is the IELTS, which shows 5.5, which is not very impressive and not necessarily mean you do a test. And that was, what was the date of that certificate? Only a year previously, wasn't it?
Yes, he arrived in 2011, I think. 2011.
Yes.
Yes.
So it's only about a year previously. So the judge makes the point, but he may have got a lot better. Sorry, Mr.
Just in fairness to my learned friend, it was 5th of October 2009.
Oh, right.
The certificate.
The certificate.
Yeah.
Yes, because that is when he entered as a student.
Deals with all of that at 43.
Yes, I'm sorry not to have this.
43,
yes,
isn't it?
and the judge. This is the real difficulty for you. The judge addresses all that and says, well, he may have got better, but it's not clear that he did. What was the evidence that he had got a lot better?
Well, in the absence of any diplomas or formal degrees from the United Kingdom, the Tier 1 application that he makes in 2012 requires a considerable degree of effort because one has to then show, by way of business plans, marketing material. There's a lot involved in a Tier 1
Well, that will show nothing about your spoken English, which is what we're talking about here.
No, I agree, my lord, but he was also interviewed in 2016 in relation to that application.
That's 4 years later.
4 years later. But our primary submission is that the upper tribunal should have taken all those factors together with the oral evidence that he gave before the upper tribunal last year. That appears to have not really been at the forefront of the judge's mind when coming to his overall conclusion. This court, when provisionally granting permission, which is found at page 40, does highlight that to some degree. The relevant paragraphs are set out 42 to 45 of the upper tribunal determination, when this court refers to whether the appellant may have a realistic prospect of success. it is said by this court when provisionally granting permission, it's arguable that the upper tribunal did not analyse the appellant's oral evidence or give adequate reasons to justify its conclusion. And this court also referred to paragraph 129 of our DK and RK by emphasising that a mere assertion of ignorance or honesty is simply not going to suffice. And that brings me back, my lord, to my very first submission, that had the appellant's oral evidence been of very average quality, then it may well be arguable that the upper tribunal was quite entitled to attach the weight that it did.
Well, it might be said this isn't much more than a mere assertion of honesty. He says, I attended, I did it. He says how long it took him to get there, which, as I say, is neutral. He gives some very basic details about the centre, which again is not really. What is this really any more than a mere assertion of honesty?
Well,
in substance,
yes, my lord, the appellant can only really deal with cross-examination by way of questions that are put to him. Those were the questions that were put to him by a very experienced presenting officer at the upper tribunal. And there is nothing to suggest that anything really more could have been put to him. The basic questions that presenting officers do ask in TOIEC cases do mainly rest on why a particular college was chosen, how they prepared for the test, the topics that they did at the test. All those questions were answered without any hesitation by this appellant. But none of that really is reflected in the determination when Upper Tribunal Judge O'Callaghan makes the overall finding.
Yeah.
And just to conclude, my lord, it is important for a tribunal to give adequate reasons. An appellant must know why he's won and lost. And the necessary illumination, illustration, exposition, in my respectful submission, are lacking in the Upper Tribunal decision. And a requirement that a tribunal explain why a party has won or lost is an indispensable one, in my respectful submission. And on closer inspection of the Upper Tribunal determination, it falls some way short. And for those reasons, we say that the appeal should be allowed.
Yeah, well, thank you. That's very succinct, and I see exactly what your point is. Well, Mr. Toman, you can no doubt be equally. Oh, well, perhaps just 2 points, which there is a point which Mr. Toman deals with in his skeleton argument, which in fact doesn't appear in yours.
Yes.
So, and I think if I may say so rightly, it doesn't appear in yours, but I just wanted there to be no misunderstanding about it. A point was taken against your client that he didn't obtain the voice recording. But that is not a point but which the judge made any reference to in his reasoning.
No.
No doubt for that reason, and perfectly appropriately, you haven't developed any submissions about it. But Mr. Toman did in his skeleton argument. So I just wanted it to be clear that
yes,
this is a non-issue because it's a non-issue because the judge didn't place any weight on it.
Indeed, my lord. And also in the note of hearing, there is the judge very light-heartedly, if I can put it that way, says that this is a point where I'm not going to hang a man on that point, but the Home Office may well do. In essence, what the judge is saying is that the authorities do not really expressly state that one should obtain a copy of a voice recording. If one doesn't, it may be that the solicitor said that they will do it and they didn't, or a recording hasn't come to light.
If I may say
there may be
so,
lots of
well,
reasons.
I have some sympathy with the judge's attitude about that. So good. I just wanted to identify that
Yes.
was a non-issue for the reason you've given.
Thank
There's
you.
also a point which you haven't developed, and again, I wasn't sure I understood it. So in a sense, I'm happy you haven't developed it, but just to make quite sure it was deliberate about the numbers attending. Now, there is something about that in your skeleton argument. If you're going to try and place weight on it, I would welcome your help about exactly what the point is.
Well, I'm
If you're not, then that's fine by me as well.
grateful, my lord. There are two features that arise from that. Firstly, my learned friend and I have had some discussion as to the number of candidates who sat these tests. In RK and DK, the upper tribunal raised concerns because the appellant referred to there being 30 candidates in the test centre, whereas the real number was 80. My learned friend says that is a transcript error, and it's not 80, it's actually 18. Not much will turn on that, but
Yes.
it's. I mean, one does wonder whether the upper tribunal would have raised.
It's a bit difficult to see how anything can turn on a possible transcript error in another case.
In another case, but the
Here
facts.
we know there are 16.
Indeed. So nothing will turn on it. The only other observation I would make is that in upper tribunal judges Lane's decision, which is found at page 69.
By the way, just on this, on the 16, my lord rightly said, of which 12 were invalid and the remaining 4 were questionable.
Yes. And just very, very briefly, upper tribunal judges Lane's decision, which is dated 12th of March 2021, found at page 68 and 69 of the bundle. One unusual feature, and I say unusual, but a feature that was raised by the Secretary of State is that the appellant did not notice anything untoward while he was undertaking this test. He didn't see that there was something going on which shouldn't have been going on. And considerable weight was placed upon that by the Secretary of State. But upper tribunal judges Lane's decision at paragraph 3, he is very unimpressed by that argument, because he says very clearly, this error alone is sufficient to lead me to set aside the decision, because the appellant himself would not have known any of the other candidates. None of the other candidates who sat the test were known to the appellant, so he couldn't possibly have seen whether there was anything unusual happening in the way they undertook the test.
Again, I mean, this is all a point about DK and RK. It's not a point that the judge attaches any importance to in our case. So
No.
where does it go? Well, thank you. That's Mr. Toman, especially in the light of those 2 clarifications, probably even less that you need to say.
Even less for me to submit.
By the way, are you? I've always thought you're Mr. Toman, but perhaps Mr. Bellara knows better. You're Toman or Tommen?
Toman.
Toman.
Either.
Sorry, Mr. Bellara, I'm not getting at you. Just wanted to make sure I was right. Yeah.
I made the same inquiry with Mr. Bellara on the pronunciation.
It did, my lord. Yes, very kindly. Thank you.
Just to summarise very briefly what my response is, there are 4 key components to a determination of a TOIEC case in my submission. The first is recognition by the tribunal that the burden of proof rests upon the Secretary of State. The second is an examination of both the generic evidence of fraud at the test centre and the individual evidence linking an applicant with fraud. The third is that it is not.
Well, sorry, just make clear what you mean by that. The generic evidence, I mean, the crucial thing is the evidence linking him to the fraud. So maybe things have moved on as a result of DK and RK, but the way we always used to look at this was, has ETS said that they believe this test was taken by proxy as a result of the tests they carried out? And secondly, have they linked that invalid test result correctly to this claimant? That's the so-called lookup tool.
That is correct.
That is sometimes called generic evidence because it's evidence of a character, or of course in a sense it's individual in each case, but it's of a character which is common to all the cases. There's then generic evidence in a rather different sense. You could have that happening at any old centre anywhere. It might have been a one-off, someone who brought along a friend to act as a proxy, in theory.
Yes.
Actually, that's rather unlikely, so it wouldn't be detected, but still. But then you have test centres which have a terrible reputation, and of which this is one of the worst, though we're told not quite the worst. Cambridge is for some reason thought to be the worst.
Cambridge is not a TOEIC test centre, I understand.
Is it not? Oh, I didn't know.
It's a historic fraud case involved with a college which was handing out certificates which it never conducted.
Oh, I see. Right. I may be making this overcomplicated, but there is a different class of evidence about particular types of centre, or maybe I don't know the Secretary of State deploys this, but I actually, as it happened, hadn't come across New London College until I read DK and RK. The other ones I was reading about, I've forgotten the names now, but there were
Elizabeth College tends to feature.
Elizabeth College, that's right. But presumably there are a number of colleges for which statistically there's variance as to how many of the tests are thought to be fraudulent. How many weren't.
My lord, the background to the distinction, and I can claim no originality here, is between evidence that shows generally what was happening at a particular test centre.
Yeah.
That's, for example, 1,400 tests, 75% overall were fraudulent. That is the generic background evidence.
Yeah.
But it's important also to bear in mind, and it will be key to the determination of the case, is what is the evidence that that links our individual applicant to.
Oh yes, because you would never do this without the ETS invalidity of his particular, what you were told was his particular test.
Yes, although my lord will remember the original, what you've kindly previously described as the stumbling efforts of the Secretary of State in the initial litigation, where all that there was the Collings-Millington statement and a look-up to.
Yeah. Well, okay, probably none of that is relevant, but since you're helpfully just giving us a general background, I want to make sure I understood what it was. So your second of your 4 points was examination of the generic evidence of the test centre and the individual evidence linking the particular applicant to the fraud. Yeah.
Third, that it's not the position of the Secretary of State. It has not been the Secretary of State's position, nor does it derive from the jurisprudence, that each and every individual who attended a fraud factory must be presumed to have cheated. The most obvious reason for that, although not the only one, is that even at a centre such as New London College, you will have seen that about 74% of tests were actually identified as individually invalid, whereas some 26% were questionable classification. And that means in this background that there hasn't been the dual human verification and electronic verification, that we have a multiple proxy test taker on the tape. Mm-hmm. But generally, the circumstances of the test mean that ETS has concluded that it cannot.
Well, what would the circumstances of the test be other than we've heard this voice on several other tapes? What sort of circumstances make it questionable if they haven't got a finding we heard this voice before?
For example, on the test that this individual attended, there was, for example, one individual tape where there wasn't a positive match between a known proxy test taker and the tape. And where that is the position, for example, the Secretary of State's position has been that one needs to interview the individual, one needs to examine what the individual circumstances were. That is not, to use Judge O'Callaghan.
So it's questionable, really. It's questionable because it's at a fraud factory.
Yes. And in circumstances where ETS is not satisfied that the test was taken under genuine test.
Well, obviously that's why it would be invalid. But why it isn't just ticked as okay is, okay, we haven't shown that there was a known proxy, but the circumstances of that particular college, the way they did business, means that it's doubtful whether anybody there did a valid test. And the fact we haven't detected a proxy may just be because it was someone whose voice we haven't seen somewhere else.
Absolutely. And then the fourth step is that what is required in each of these appeals is an in-the-round assessment of all the evidence. Now I will deal with the remainder of my submissions in 3 steps. First of all, I look at the determination of Upper Tribunal Judge O'Callaghan. Secondly, I will dip very briefly into the learning on setting aside decisions on the grounds of error of fact. And then thirdly, I'll deal very briefly with the specific grounds of appeal.
Okay.
For the determination of Upper Tribunal Judge Callaghan, I am still in what we call the supplemental bundle.
I don't mind. I'll go.
Happy to go with the core bundle.
I know my way around it. Which page?
This is page 52 of the supplemental bundle.
Yeah.
And the structure that I'd invite the court to note is, first of all, paragraph 14 onwards. The judge summarizes the respondent's evidence.
Yeah.
That starts with the evidence linking the applicant to the fraud. That is the lookup tool identification, the source data confirming appellant's test results have been cancelled. That's paragraph 14. There is then a consideration of what I've called the wider generic evidence of test centre fraud. And my lord, that bears out the point you made a moment ago, which is about the modus operandi, the evidence that was of the modus operandi at London College. And you'll see in the citation, paragraph 17, which is that both genuine candidates and proxy test takers were seen at the test centre with the proxy test takers taking the tests on their behalf.
So where are you now?
Paragraph 17.
Yeah.
Under paragraph 13, that's a citation from the report into fraud. And
Yeah.
Paragraph 17 of the sub-citation, documents relating to TOIEC exams were found within the ITCs, that should be from the director's home address, that were searched on the 17th of July 2014. The documents list each test date for the entire testing period and alongside candidate names of the pilot who was to take the test on their behalf. And then judicial notices taken, paragraph 18. This is something that was also remarked upon in DKRK, of the fact that that evidence of fraud in New London College had satisfied the criminal standard of proof in the prosecutions of Mr. Kulagatla and others. There's then what in my submission is a careful summary of the evidence of the appellant. And so my lords have the reference. Paragraph 20 deals with the import.
Yes, thank you.
Score of 5.5. And just so I've read it in open court, what that indicates for modest users has partial command of the language, coping with overall meaning in most situations, though is likely to make many mistakes, should be able to handle basic communications in his own field. There's then a summary of the appellant's evidence of his attendance at the test centre, his evidence of the numbers attending, and a summary, paragraph 25, of responses to questions.
Just remind me, I'm not sure this is at the heart of it, but in order to apply for Entrepreneur Migrant leave, do you already have to have a business, or do you simply have to have a business plan?
One needs to have a business plan, and one needs to have a sum to invest. Which is
Exactly. By definition, you can't and you shouldn't already have a business because you're, assuming you've previously been on present or on student leave, you shouldn't be working.
Yes.
Yeah.
Although, in fairness to my learned friend, one also needs to provide evidence of English capability. We have, in fact, the standard in the bundle that was required.
Yes, no, I suppose the point I was simply getting at was that a point that seemed at one point to be being made, but I'm not sure really was on the timing. Well, how could I have run my business if my English was so poor? But the answer is, at the time that he took the test, he shouldn't have been, and certainly wasn't, running a successful business. He was hoping to set one up.
Certainly not in this country, yes.
Yeah.
And just so I've dealt with it, so I don't need to come back to it, the relevant chronological markers you have for that point is paragraph 3 of the Upper Tribunal determination.
Yeah.
You will see remembering that the test that we're discussing was taken in July 2012.
Yeah.
Leave was curtailed to expire on the 14th of October 2012. That's the student leave. And then he made an in-time application for leave to remain on the 15th of
We
September.
don't know why it was curtailed. Well, it was planning to the college to close, wasn't it?
Yes.
Yeah.
And then on the 20th of June, he's granted leave to remain until June 2016. So any entrepreneurial activity would have fallen post-test.
Okay.
And also there's a degree of circularity to the submission by my learned friend, because we now know that the way he was able to demonstrate his English ability for the purposes of this test was by submitting a TOIEC certificate, which the Secretary of State's position is, and the Tribunal has found, was obtained by fraud. So in terms
Didn't
of...
quite understood. Anyway, this is a marginal part of the case, but
Yes. But the submission I will make in relation to that is the entrepreneurial activity, any acumen skills he displayed in that period would have been post this test. So the appellant's evidence is summarized 19 to 27, and I've taken you to paragraph 20. And then there is a very extensive analysis section to the determination, which starts at paragraph 36. And I invite you to highlight third line down paragraph 36, where the judge directs himself correctly, looking 6 words in, the burden of proof in respect of the allegation of fraud rests upon the respondent, who is required to establish that it's more likely than not the appellant used deception in a previous application. There is then a discussion of the circumstances of the IELTS test, paragraph 37.
yeah.
And there is setting out in general terms as to where the TOIEC, the wider TOIEC jurisprudence had got to.
Yeah.
That is principally the developments in DK and RK and the generic consideration there of chain of custody issues, the extent to which ETS can or should be presumed to be a safe harbour of test recordings as between test centre and ETS. Then paragraph 42 onwards is material for our purposes, which is consideration of the material factors in this appeal. And in my submission, read together, those paragraphs provide an in-the-round assessment of the allegation of fraud and whether it had been demonstrated on the balance of probability. Paragraph 42, that's the starting point, the fact that there is a positive lookup tool match. There is also note of the fact that 75% of the tests taken on the day the appellant attended found to be invalid. There's the wider evidence of fraud, the 74% marking of 1,423 tests taken. In paragraph 43, in terms of looking beyond the TOIEC evidence, the judge does expressly direct his mind to the fact that the appellant contests the allegation of fraud and has done since 2016. He addresses his mind to the care with which personal circumstances, both as to attending the test centre, taking the required tests, and the subsequent impact of the allegation has been set out in evidence, expressly indicates that he's considered that evidence. But he also identifies as the high point of the rebuttal of the fraud allegation that the appellant's case was that his English standard was of such quality that there would have been no need, there would obviously have been no need for him to cheat. And he makes a finding that, judging by the IELTS document, the document that the appellant had himself.
Well, we have read all this, Mr. Chairman.
I'm grateful.
Your point is that the judge carefully looked at the points being advanced in the evidence, including the oral evidence, and explains why he doesn't accept them.
Yes, that's a short point.
and he directed himself correctly as to the relevant law. In that situation,
burden of
we're
proof.
in classic territory of it all being a matter for the tribunal of fact.
Yes. It may not, given those indications, it may not be necessary to draw your lordship's attention to the three cases in the authorities bundle that deal with the approach of this court to allegations of fact. But
No,
because
I don't think it is.
because of the prominence in my learned friend's submission of the reliance upon the demeanour, the lack of hesitancy in giving the response.
Yes, to be fair to Mr. Billara, I think comes close to being a reasons challenge. It's simply saying, effectively, Mr. Billara's case is the judge didn't face up to the fact that the claimant, he was happy to find that the claimant was lying. There isn't actually a sentence here saying, I do not find his evidence credible because it was overbalanced by, or because although there was nothing explicitly wrong in it, or obviously wrong or inconsistent in it, it was overbalanced by the generic evidence. But that is in effect what he was saying, must be.
Yes.
But I think the criticism is that he didn't face up to saying it.
Well, that wasn't the only observation the judge made on that aspect. But the one thing that the judge could test with objective evidence of the appellant's case was his suggestion that he's at this marvellous standard of English when he
Yes.
entered. And looking at the reverse side of the very document handed up by the appellant to him to prove that,
Yeah.
it was quite clear not only that was not the standard he enjoyed, but also, and I'm looking at line 2, that it was not of the high standard he has subsequently asserted.
Yeah.
So to that extent, the one thing that could be checked, and the account had proved to be not the position and to have been over-egged. But in terms of whether more was required, the generic circumstances were set out, but also specifically on this day. The problem for the appellant was that 75% of tests on that day, not only 75% had been found to be invalid, but also that his has been found.
Right.
Just to emphasize a non-point, at paragraph 20 of my skeleton argument, I dealt with the failure to obtain a test recording from ETS. I was there meeting a challenge to the reasoning of the judge, and I hope I set out clearly that that was not actually
The
fact
water
that the
under the
judge
bridge
relied
is not a challenge that's being maintained.
No.
So.
No. Let me then very briefly make sure that I've dealt with each of the sub-issues. Yes, we've dealt with the relevance of the Tier 1 activities. On the first ground, one additional submission made by my learned friend relates to numbers in on his test day, numbers in DKRK.
Well, I think that point also was gone. So.
That point is gone. Yes, I mean, just to say this, to set in context where the numbers come from in DKRK, it's in
Well,
fact...
do we need...
I mean, just so I've made this clear, they come from a citation at paragraph 100 by the Tribunal. This is page 203. This is a recitation of my cross-examination of Ms. RK. You
I
will find
suppose it might be useful for posterity for us to record in the judgment that that was a typo. Is that right?
that might be useful. I've given my learned friend the relevant figures. It's in fact also, I was cross-examining, as you'll see in context, in relation to the listening and reading test, the first test she attended, rather than a speaking and writing test. And in terms of the issues and the assessment of credibility, I entirely endorse what this court has said about each of these appeals being evidence-specific.
thank you very much. Unless my boards have any questions. Yes, Mr. Ballara.
Lordships, just very, very briefly, I'm grateful to my learned friend for his very helpful submissions. My Lord, at page 40 of the bundle, there is the provisional grant of permission from this court. And this very much goes back to what his Lordship very kindly raised during my friend's oral submission. The consequences for the appellant are very serious. There is an allegation of deception, fraud, which has been made against him. In my respectful submission, the concerns raised by this court when granting the permission was whether the upper tribunal had given sufficient and adequate reasons as to why the appellant's oral evidence should be found to be not credible. In my respectful submission, when looking at Judge Callahan's decision in the round, although parts of the oral evidence are referred to at paragraph 43, there is no real explanation or reasons given by the upper tribunal as to why the appellant's oral evidence should be given no weight at all. Paragraph 44, the upper tribunal quite rightly says that there was a high level of fraud and criminality. That is not in dispute at this particular college. But nonetheless, RK and DK made it very clear that cases of this nature must still be approached with a degree of care, and the evidence must be considered carefully when considering whether an appellant has given a plausible explanation.
But at paragraph 44, the judge made a finding of fact that the entirety of the test centre on the 18th of July was devoted to fraud.
Yes, my lord, that did...
That's a critical finding of fact.
It is. That did also feature in the provisional grant of permission from this court, which is found on page 40. It was said that the judge did not give clear reasons as to why he found that the
Said that there was an arguable case.
Yes, that is correct, my lord. I
But there
agree.
clearly was an evidential basis for it. There were, of the 16, 12 were invalid, 4 were questionable, and Mr. Toman has clarified what questionable means in this context. It was perfectly legitimate, wasn't it, for the judge to say, on those figures, although the 4 they weren't able to identify reliably at a rate, or certainly the voice of a proxy, nevertheless, given the overall picture, those too will have been taken by a proxy.
Yeah.
That's a perfectly legitimate, common sense conclusion, isn't it?
Yes, my lord, I agree. The issue really for this court is to determine whether the lack of boldly saying, in order for the appellant to understand why he's lost his appeal, whether the upper tribunal failed to give adequate and cogent reasons as to why his oral evidence and the documentary evidence taken in the round failed to discharge the evidential burden which clearly fell on him. Those are my submissions.
Thank you very much indeed. We would hope to have a decision for you later this morning. We will rise now. I think if you can be back by 12, I don't promise we will be, but we will hope to be then or not long after.
Yes.
If I go